The attorney had 18 minutes. That is how long she had with Denise and Kavon before they walked into juvenile court. 18 minutes in a hallway under fluorescent lights, papers moving fast, court officers calling names, another family crying at the end of the bench. Kavon trying to read legal words he had never seen before while wearing the only collared shirt he owned. The attorney was not a bad person. She was overloaded. 47 cases that week, maybe more. That matters because families are often told the system works through careful decisions. A lot of the time it works through speed, and speed changes everything. I'm speaking to you as someone who worked inside this system. I was a DJJ program director. For more than a decade, I sat at intake and read probation conditions line by line to young people and their families. I saw what happened after the signatures. I saw which kids made it through supervision and which kids got pulled deeper into the system over technical violations that had nothing to do with a new crime. So this video is about slowing that hallway down, because a plea deal is not just a quick agreement to move on. It is a legal contract that can shape your child's school life, work life, housing opportunities, future court cases, and daily routine for months or years. And too many Black and Latino families are being asked to make those decisions fast, under pressure, without the full picture. Most juvenile cases never go to trial. They end in pleas. That means no full hearing where every witness is questioned and every piece of evidence gets tested. Usually it becomes a negotiation, an agreement, a deal. Families experience it like this. Somebody hands you paperwork and says this is the best offer available. What most families are not told is that there are usually different pathways inside that offer. The first pathway is adjudication. That is the standard plea most people get. Your child admits to the charge. The court enters an adjudication on the record. In juvenile court, they may avoid the word conviction, but understand the real-life effect. Future schools, programs, jobs, military applications, scholarship applications, future prosecutors, future judges. That adjudication can still follow your child. Then there's deferred adjudication. Different states use different names, but the idea is similar. Your child agrees to conditions, probation, programs, rules. But if they complete everything successfully, the court may not enter the adjudication. That difference matters. A completed deferred outcome can look very different from a formal adjudication years later when your child applies for college, work, or housing. Then there's diversion, sometimes called informal adjustment, sometimes pre-petition diversion, sometimes community diversion. This is the pathway families almost never hear enough about. In some diversion programs, the case stays out of formal court completely. Your child completes counseling, classes, community service, or another requirement, and the case may never become a formal delinquency record. Not every charge qualifies. Not every county offers it equally. But families deserve to know these options exist before they sign anything, because once paperwork is signed, negotiating power changes. Now here's where things become dangerous. Families focus on the charge, but the conditions are what control daily life. I used to read these conditions aloud during intake, and after a while I could look at certain conditions and already know which kids were at risk of violating. Not because they were dangerous, because the conditions did not match their real life. Curfew, school attendance rules, mandatory check-ins during work hours, drug testing, no contact orders, program attendance across town, search conditions, fees, electronic monitoring, mental health requirements with no transportation support. Every one of those conditions sounds manageable on paper, but juvenile probation is lived in real neighborhoods, real apartments, real bus routes, real work schedules. A curfew sounds simple until a teenager works evenings to help pay rent. Weekly check-ins sound simple until the parent has no car and cannot lose another shift. Program attendance sounds simple until 2 buses are late and now the child is marked non-compliant. That word matters, non-compliant, because every condition is another opportunity for violation. And this is the part many families do not understand when they sign a plea. A technical violation is not a new crime. That's important. A technical violation means breaking a supervision rule, missing an appointment, being late to curfew, missing program hours, testing positive, skipping school, failing to complete paperwork. One missed ride home can become a violation. One anxiety spiral can become a violation. One misunderstanding at school can become a violation. And once a violation report gets filed, your child can end up back in court, sometimes detained, sometimes giving stricter conditions, sometimes placed deeper into the system than where they started. The danger is not only the original charge, the danger is surviving supervision. Kavon learned that the hard way. His probation conditions included an 8 o'clock curfew, but Kavon worked closing shifts at a grocery store. He had been helping his mother with bills since he was 15. Closing shift ended after 9. Nobody adjusted the curfew. Nobody asked about his work schedule before the agreement got signed. So the plea that was supposed to help him stay out of detention cost him his job instead. That happens more than people think. And I need families to understand something else. The pressure in those courthouse hallways is structural. The calendar is crowded. The attorney is overwhelmed. The prosecutor wants movement. Your child is scared. You are scared. The offer is presented like it might disappear if you do not accept it immediately. That environment pushes families toward fast decisions, especially working class families, especially Black and Latino families who are already overexposed to policing, school discipline systems, probation surveillance, and pre-trial detention. Research across different states has shown that Black youth are more likely to be detained before disposition, less likely to receive diversion opportunities, and more likely to receive stricter supervision conditions for similar behavior. That does not always look dramatic in the moment. Sometimes disparity looks like this. One family gets diversion, another gets formal probation. One family gets reasonable reporting conditions, another gets conditions impossible to maintain without transportation, money, flexible work schedules, or private support. And detention changes negotiation power. If a parent believes saying no to the plea means their child might sit in detention longer, that creates pressure to sign quickly. That is real. So what can families actually do before signing? First, slow the process down. You can ask for time. You can say, I need more time to understand the conditions before my child signs anything. That is not disrespectful. That is parenting. You can ask for a continuance. That means requesting another court date so the family can review the agreement carefully. Second, ask what pathway is actually being offered. Ask directly, is this adjudication? Is deferred adjudication available? Was diversion discussed? Those questions matter because families cannot choose options they were never told existed. Third, get every condition in writing, not summarized, written. Read every line. Ask, what is the curfew? How often are check-ins? What happens after one missed appointment? Who pays for testing? Can probation search my child's room or phone? Does this interfere with school or work? What counts as a violation? Those are not hostile questions. Those are survival questions. Fourth, explain your real life before conditions are finalized. Bring school schedules, bring work schedules, bring transportation issues, bring medical documentation if needed, bring IEP paperwork if your child has learning differences. If your child works evenings, say it clearly. If your family depends on public transportation, say it clearly. If language interpretation is needed, say it clearly. Conditions should fit real life, because probation that cannot realistically be followed becomes delayed punishment. Fifth, ask about long-term consequences immediately. Do not wait until graduation season or college applications. Ask, will this create a permanent adjudication? Can this record be sealed later? What does a future employer see? What does immigration see? That last question is critical for immigrant families. Some plea outcomes can affect immigration status in serious ways. Families need specialized legal advice there immediately. And finally, ask this question before signing anything. What realistically happens if my child violates one condition? Not the official answer, the realistic answer, because that answer tells you what kind of risk your child is actually carrying. I want to end here carefully. This documentary is not telling every family to reject every plea deal. Sometimes a plea truly is the safest outcome available. but families deserve informed decisions. Families deserve time. Families deserve explanations in plain language. And young people deserve conditions built around rehabilitation instead of failure traps. Kavon finished probation. He completed the program. He stayed out of trouble. But the adjudication still followed him into applications later, the disclosure conversations, the explanations, the delays. And Denise still thinks about those 18 minutes in the hallway because she was trying to protect her son. Most parents are. That hallway is full of people trying to protect their children with incomplete information. So if you are watching this before a juvenile hearing, remember this: slow it down. Ask questions, read every condition, ask about deferred adjudication, ask about diversion, ask what happens after a violation, and do not sign paperwork you do not understand, because 18 minutes is not enough time to decide the shape of a child's future.